Have you ever wondered what really happens when someone sues another person in India? It's really nothing like you see in the movies. It's a very precise, step-by-step journey, and it's all governed by a strict set of rules. So today, we're going to dive deep into the anatomy of a lawsuit and see exactly how it all unfolds. You know, the journey from a simple disagreement to a final binding court order is an absolute marathon of paperwork, evidence, and arguments. We're going to track this entire process, right from the very first document that gets filed to the final bang of the judge's gavel. So what keeps this whole complex process on the rails? Well, it all boils down to one master document, the Civil Procedure Code of 1908, or as lawyers call it, the CPC. Now, I want you to forget about some dusty old law book. Think of this as the official rulebook for the entire game of civil justice. Its main job is just to make sure everything's fair, everything's in order, and that both sides get an equal shot at presenting their case. Okay, so here's our roadmap for today. We'll start with the rulebook itself. Then we'll see how a lawsuit is actually born. We'll watch the battle on paper, then step into the courtroom for the trial itself, and finally, we'll even explore what happens after the judge's verdict is in. You might be asking, why are these rules so incredibly detailed? And the answer is actually pretty simple. It's to make sure that disputes are won based on facts and evidence, not based on who has the most power or who can shout the loudest. The CPC is all about creating a level playing field where everybody knows the rules of engagement before they even start. All right, let's get to the starting line. How does a simple grievance, a problem you have with someone, transform into an official court case? It all kicks off with a few very specific, very crucial moves. First up, a formal document called a plaint has to be filed. And it has to be filed in the correct court. Choosing the right one is absolutely critical. Once the court accepts that plaint, they issue something called a summons to the other party. And that's the signal that the legal clock has officially started ticking. So this plaintiff thing, what is it really? The best way to think of it is as the opening chapter of the lawsuit. It's the official story from the plaintiff, that's the person doing the suing, and it details exactly what happened, why they believe it was wrong, and precisely what they are asking the court to do about it. And this is where that rulebook gets incredibly specific. A plaint can't just be a vague complaint. Nope. Order 7, Rule 1 of the CPC demands total clarity. You have to state who's being sued, the exact facts of the case, why this specific court has the authority to hear it, and the precise outcome the plaintiff wants. It has to be all laid out. Now, this example, and this comes straight from Section 19 of the Code itself, illustrates this idea of jurisdiction perfectly. So the person who is wronged, B, has a strategic choice. They can either sue where the incident happened, in Calcutta, or they can sue where the defendant, A, actually lives, which is in Delhi. The plaintiff has to clearly justify why the chosen court is the right place. So once that plaint is filed, the court issues a summons. And let me be clear, this is not just a friendly letter. It's a formal command from the court. And its whole purpose is rooted in fairness. It's to officially notify the defendant that they're being sued and to command them to show up and respond. Without this step, the whole case just grinds to a halt. All right, the lawsuit is officially underway. But hold on, we're not running off to a courtroom just yet. Before anyone even sees a judge, a really crucial battle is fought entirely on paper. This is called the pleading stage, and it's where the entire case starts to take shape. Just think of this as a formal, point-by-point debate, but all in writing. The plaintiff fires the first shot with their plaint. Then the defendant has to return fire with something called a written statement, where they respond to every single allegation. They either have to admit it, deny it, or sometimes claim they just don't have enough information to answer. After that initial back and forth, we move into what's called the discovery phase. The whole point here is to prevent any kind of trial by ambush. There should be no gotcha moments. So both sides get to demand evidence from each other. They can send written questions, demand to see key documents like emails or contracts, and even ask the other side to just admit to certain facts that aren't really in dispute, just to save time later in court. So the paper battle is over. All the cards are on the table. And now the case moves to its most famous phase, the trial. This is where all those theories and documents finally meet reality. It all comes out through live witness testimony and arguments made directly in front of a judge. A trial isn't just chaos. It's actually a very structured process. First, The judge boils the whole dispute down to the key issues. These are the core questions they need to answer. Then, the plaintiff gets to present their case. After that, the defendant presents their evidence and witnesses. And finally, both sides get one last shot to persuade the judge during their closing arguments. Here's a cool little detail from the rulebook, from Order 18 actually. It's about who gets to speak first. Normally, the plaintiff has what's called the right to begin. But there's a really interesting exception. If the defendant says, you know what, all the facts the plaintiff said are true, but here's a legal reason why I should still win, well, then the whole burden of proof shifts, and the defendant actually gets to open the arguments. So after weighing all the evidence and hearing all the arguments, the judge delivers their judgment. That judgment is then formalized into a very important document called a decree. This is it. This is the final binding decision. As the law itself says, this document conclusively determines the rights of the parties. This is the finish line.
But wait, hang on a second. Just because the judge has spoken doesn't mean the story is always over, not by a long shot. The legal journey can still have a couple of final, really crucial chapters.
Here's something a lot of people don't realize. Winning the case is one thing, but actually getting what you've won is another. A court decree isn't a magic wand. Just because a judge orders the other side to pay you money, for example, doesn't mean a check will just show up in the mail. The winning party often has to start a whole separate process called execution to actually force the loser to comply and collect whatever is owed.
Okay, so let's flip it. What if you're on the losing side and you are absolutely convinced the judge just got it wrong? Well, the journey still might not be over for you either. The CPC provides a kind of escape hatch, the right to ask a higher court to review the decision. And this, of course, is called an appeal.
The best way to think about the appeals process is like climbing a ladder. The first appeal, under Section 96, is your first step up. It's a pretty broad review of the original case. If that doesn't work out, you might be able to climb to the next rung, a second appeal to the High Court. But this one is much tougher. It has to be based on a major legal mistake, not just because you disagree with the facts. And at the very, very top of the ladder is the Supreme Court, a final step that's reserved only for the most important cases with significant legal questions. So, after all that, is it a complex process? Yes, absolutely. It can be a maze. But every single one of these detailed rules, every step, every document, it all exists for a reason. It's there to make sure that disputes are settled with reason and evidence, not just by power or by force. This whole complicated legal machine is what ultimately forms the bedrock of a society that's built on rules, not might.